couple of minutes and other people are joining in. I can see people joining in. And we'll be ready to start. Good afternoon. Yes, good afternoon. Hi, welcome. Thank you so much for joining the webinar this afternoon. And today we'll be discussing 6 things to do to meet GDPR third country requirements, which is actually the rave of what's going on now in the UK. Before I start, I want to tell you that please feel free to type in any questions during the session into the questions section. You see that on your control panel. So feel free to type in any questions you may have, and I'll be happy to answer them during the question and answer portion of this webinar. Once again, I'll say thank you for joining the webinar. Who we are. We are Risk Crew, and you can see us, our slogan is shelter from the storm, because if you're in data protection, risk, compliance, you know that the storms do come. So we are an elite group of information security governance, risk compliance, testing professionals who provide 100% satisfaction guarantee. What we're trying to tell you here is that we have run and implemented successful projects in diverse sectors of the economy, such as defense, health, finance, higher education, non-profit organizations, and we are confident in our expertise in ensuring tailor-made solutions, because every company is different, every business is different. So we do try to tailor all our solutions to what suits you. My name is Ursula Baye, and for me to be part of this elite group, obviously, I am an information security governance risk compliance professional with a number of years of experience under my belt, both with data protection and information security. I am a certified data protection officer, and of recent, the rage is the GDPR, and now with Brexit, with what's going on. So here we are to discuss the third country requirements for the GDPR. Now, for this, what we're going to be discussing today is we have 4 main topics actually, and then we have a bit that does question and answers for whatever questions, you may have. We have where we are now, what is actually happening now, real time, and how did we get here, where we're going to, and things to keep in mind for the journey ahead, because it is a journey ahead. If you've been in data protection and compliance long enough, you know that it's a journey that could have bumps, but we keep on going. Who needs to apply to whatever requirements are required with this GDPR, and who is exempt with the third-party requirements, and 6 key actions that we need to comply with the GDPR third country requirements. We call them key actions, and we know what we're trying to do here is be prepared, because we're just getting into a season now, so we're saying we need to be prepared. In data protection, we all remember when GDPR was first announced, the time limit were given to get ready, and how long it took some of us. I'll put some of us so that nobody is exempt from blame. And we had all this rush of getting ready for GDPR. So what we're trying to do here is possibly preempt, you know, the rush season and be ready when things come up. So where we are now, we are currently in what is known as a transition period. On the 30th of January 2020, the United Kingdom, when it came to data, entered what we call a transition period. This is because of our withdrawal from the EU, and this transition period is meant to last to the 31st of December 2020. Currently, as we are now, the United Kingdom will remain in the single market until there is a long-term relationship that is agreed. During the transition period, which is also known as the implementation period, the ICO states that the rules of GDPR stay in place. So basically, in this transition or implementation period, as it's known, nothing is really meant to change. And during this period, the EU law will continue to apply in the UK. until such a time as the agreements have been reached. Just a second. Sorry about that. I needed to adjust my screen. Thank you. So now, with the UK leaving the EU, what has happened is that the UK has been reclassified as a third country. And now there is a body that has been put in place. It's called the UKTF. And this body is meant to be coordinating all the issues that are meant to be pertaining around UK's withdrawal from the EU, everything pertaining to the future relationship, what's going to happen with the withdrawal agreement, what's going to happen concerning adequacy decisions. This is the body that is actually in charge of making sure of all these decisions. But for now, where we are at in this transition period, nothing really moves. But then again, it's just a preparation to get ready for what might move, what might change, and what to expect with the change, and just being ready for what could be coming up. How did we get here? Obviously, EU's data protection laws have long been regarded as gold standard all over the world. But what brought about the GDPR coming so much into play? 25 years ago, the technology we have today is not what we had then. The way data is transferred from one country to the other wasn't what it was yesterday. So obviously, with data protection, we have to keep up with what technology is giving us. And this conversation went on, the preparation and the battling for GDPR went on for 4 years until finally the Data Protection Directive was approved in 2016, and then the GDPR came into play. And this was designed really to ensure that all the privacy laws across Europe was harmonized, and to protect and empower the citizens, as well as to ensure that organizations actually approach data privacy in the proper manner, not pushing it under the table, not having a privacy policy in your company and then pushing it, oh, we've written it, we've done that, it's done and dusted, but actually implementing what is put down in the policy. Therefore, that's why GDPR was brought along, because with the directive, with every country, it was actually open to interpretation because it was a directive. But with the regulation, is a stated law that has fines attached to it. And everybody knows that we don't want to get those fines. So the GDPR was now recognized all over the EU, and it was put into implementation. Companies came into play, and everybody ran around. We've had 1 or 2 data breaches and celebrated data breach cases that have really gone haywire. But January 31st brought another click to it, as the UK left the EU and now has been classified as a third country, giving us a change of status and a transition period of preparation. And now we think about, where is it we're going to with all of this? Where do we expect to be at the end of this transition period? Assuming all goes to plan, and if everybody has been, you don't have a choice. If you're in the UK, you have to sort of keep up with what's happening with Brexit and what was not happening. We can be assured that in as much as there is a plan, there could be kinks and bumps along the way. But what does this actually mean for data flows in and out of the UK? The United Kingdom government has acknowledged that it will recognize all EEA countries under its own adequacy ruling and incorporate all existing EU adequacy decisions. And this will allow organizations within the EU to continue to facilitate data transfers from the UK to these countries. You may wonder, what are we talking about when we say the UK will acknowledge all EU decisions? Basically, what has happened is that the UK now has what we call the UK GDPR, which is actually the same regulation with the GDPR. It's just that now it has been implemented as domestic law. When this comes into play, what we are saying as the UK is that we're going to acknowledge the decisions that have been made by the EU, in that way ensuring that there is a data flow that goes along with it. GDPR restrictions will apply to personal data being transferred into the UK unless the EU establishes that the UK is an adequate country. We have to keep that in mind because that is still a decision that is meant to be made. Because with this decision, it requires that the European Commission will assess and approve the UK for adequacy. We will need to demonstrate adequacy to meet GDPR requirements for processing EU data. Organizations based both in the UK and the EU would definitely need to update their privacy policies. The UK government has stated clearly that it will continue to comply with the GDPR post the transition period, meeting third-party requirements. Those are the expectations we expect after the transition, or that's the plan of where we are going to. Things to keep in mind, is that the transition period actually lasts till the 31st of December 2020. We're still very early in that. We're in March. And as we can see, anything can happen. But one thing we do know for sure is we do need to have a data transfer agreement in place. And if there's no data transfer agreement in place, alternatives need to be looked out for. One alternative that stands out amongst all others is the use of standard contractual clauses to include in GDPR-style data protections in contractual agreements. These are especially useful for sending data to countries where data protections aren't thought to be adequate enough for the EU in order to safeguard citizens' data. That is one option if we do not come into a full agreement with the EU on how data is meant to be handled. So let's have a fun fact here. The EU and Japan adequacy agreement actually took 2 years to become final. So what do we expect for the United Kingdom? We do know that the United Kingdom was quite instrumental in putting the GDPR into place. Do you think that will give us extra leg room? Will it give us extra leg room? Will it make it okay? Will they speed up our own process for adequacy? What's it going to be? Can we be exempt from all the things that require to be put in place for adequacy to actually be put in place? What do we expect about that? But it's fun. Well, not a fun fact. Well, for me, I don't think it's fun, but it's a good fact to know that the EU and Japan adequacy agreement actually took 2 years to become final. Sometimes we wonder what took so long. Did they not have processes in place that they took to? What was it that they were searching for? What was actually the impediment that made it take so long? We're yet to find out. Then we have here, how is this adequacy actually determined, and who determines who is adequate, how we're adequate, it is actually the European Commission that has the power to determine that. And this is based on Article 45 of the regulation to decide whether a country outside of the EU offers an adequate level of data protection. Having discussion with somebody one day said that, for him, he would think that the UK should have it automatically because we just stepped out of the EU. So obviously for us to be under GDPR, we already have everything in place. But wait and see. But what it involves is a proposal from the European Commission, an opinion of the European Data Protection Board, approval from the representatives of the EU countries, the adoption of the decision by the European Commission. I think for me, one of the things is approval from the representatives of the EU countries. That means each and every country in the EU has a representative that is going to approve or disapprove according to what their country looks at. Now, the UKTF, we have, as I said earlier on, there is an EU body that's coordinating every issue that is related to UK's withdrawal from the EU. And the most recent thing that has been said concerning our adequacy, which some may look at it in a good light, some may not. For me, it was rather vague. But on the 10th of January 2020, this UKTF, which is the European Commission's task force for relations with the United Kingdom, actually gave what they called an encouraging update on the potential adoption of an adequacy decision under the GDPR in relation to the UK's level of personal data protection. And they only promised that they would start to look at an assessment in respect to UK's adequacy as soon as possible after UK's withdrawal. Some people said that was some people said that was encouraging, that they did say they'll start immediately. Others, for me, I think it's vague. I leave that to opinion. You can drop your opinions down in the question box. You can drop your opinions down in the question box. And I want to remind you, if you do have questions, please put them in your question box, and we will get to those questions after. But for sure, it is not automatic, because unless a Brexit deal is reached between the UK and EU, which covers data protection and data transfer arrangement, the adequacy decision is definitely not automatic. The Commission's current position is that it will not. It has just started to process our adequacy, but we've heard nothing since that announcement was made. The European Commission has said that it will endeavor to adopt an adequacy decision by the end of 2020, provided all applicable conditions are met. Now, when the European Commission does do this, who is exempt and who needs to comply? Basically, it stands that now from the ICO, if you are based in the UK and do not have a branch, office, or additional establishments in any other of the EU or EEA states, and you do offer goods and services to individuals in the EEA, or you do monitor their behavior, then your organization will need to comply with the EU GDPR regarding this processing, even after Brexit. The only people that are exempt is if you are a public authority, or if you can prove, because it comes down to proof, that your processing is only occasional and that is of low risk to the data protection rights of the individual and does not involve large-scale use of special category or criminal offense data. Do you know, now I would like everyone to get involved in this, because this was a bit of a brainer for me. Do you know what countries currently do have the adequacy agreements in place with the EU? I'll take Japan out of it because I did mention Japan. Can I have people put down their answers to that in the question box? Let's see who's going to get it. I wish I could say I had a prize to give you for that, but no, it's just information. If you know at least 3 countries that are under the adequacy agreement, that currently do have adequacy agreements in place. I see that. Oh, wow. Yep, I'm getting answers there. All right. So these are the countries that actually have adequacy agreements in place. We've got Andorra, Argentina, Canada, Faroe Islands, Guernsey, Israel, the Isle of Man, Japan, finally got this, Jersey, New Zealand, Switzerland, Uruguay, and the USA. I must say that with the USA, it's bound to what we know as the Privacy Shield. What we know as the Privacy Shield. So that's good. So possibly we'll have the UK joining this. I wonder, did every country take so long? I think that's a question we should ask ourselves. Did every country take so long? Why was Japan's own such a long process? I think it's something we could look into, and find out how that's going. So now we have the 6 key actions that we need to look at when we're going to put this into play. For most of us, or most of you, that have been in data protection for a while, these steps may look commonplace, but always remember we have that twist now that we're no longer part of the EU. we are now regarded and classified as third country. So it is an opportunity to go around and do everything again, probably get a better view of what you do have on ground, how do you improve it. But the basic first 6 steps we're going to look at today is you need to conduct an audit for EU personal data. You need to inform them why you're processing their data, assess processing activities for potential improvement, amend your data processing agreements with the vendors, and then this is a big one because it's what everybody needs to now do if we fall into this category, is designate an EU representative, then establish data breach reporting procedures. Let's take it step by step and see what we're talking about. Now, the first thing is that you need to determine what personal data you process and if any of it belongs to the people in the EU. Because I'm going to assume that a lot of us we are either working with businesses that have been in operation for a while, or we consult with businesses like that. But whatever it is, wherever you are at, it is an opportunity to take a complete audit of what you do have. And if it is EU personal data, you now need to determine whether the processing activities are related to offering goods and services, irrespective of whether these goods and services are connected to a payment. And once you've ascertained that, and you know that you are now, you have now verified what you store and transmit as EU personal data, you now have to now go on to the next steps. You now have to classify, okay, this is the EU personal data I have. Irrespective of how you had it before, you now have to put that on a different classification and know that this is all the EU personal data that I do have. And having had that, you now have to have your way of informing EU data subjects why you are processing their data. These steps are not what is strange to us in the data protection world. We all know that we have to get consent, and consent is not the only way. But now, in informing your data subjects that this is what's happening to their data, you have to take into consideration that you are now in the classified as a third country. There are different ways that in which we are qualified or allowed, or it's legal for us to have this data. We have the consent of the individual, the performance of a contract, compliance with a legal obligation, a necessity to protect the vital interest of a person. We know all that, but now know that in informing them, you're going to have to update everything you've put out there in your privacy policy, taking note that you are now a third country, or rather you are now in the process of being, as a third country. That's how you'll be operating. And when you're considering, that's another thing, for your potential improvement, you now, for every process that you now have to consider, okay, putting a DPI into place. Even if you've done a DPI before, DPI, I assume we all know, is a data protection impact assessment. And it will help you understand the risk to the security and privacy of the data you now process, and decide ways to mitigate those risks. Now, even when you're implementing your data security practices, such as using end-to-end encryption and organizational safeguards, in order to limit your exposure to data breaches. Now, the main point is that you have to take into account that you're now considered a third country. What are the different things you now have to look at when considering in a third country, being a third country? Then we look at, definitely we all know that we have to do data protection by design and default, and that limiting the data control, limiting the collection of data in the first place. You have to be sure you do need the data you are collecting. You limit who can access that data, the impact assessment to mitigate the risk, how you do your record keeping, you limit your processing, and all that is involved. And once you're doing that constantly, you have what we call continual improvement. Now, for amending data processing agreements with the vendors, it's where, as a controller, you are the one that is held accountable for whatever third-party clients or third-party processors that you do have. So now in the data processing agreements, these are most likely agreements that need to be rehashed. the most likely agreements that have to be looked at once again, put into consideration that we're now a third country, and then getting the clauses that now have to be put in the amendments, that in the agreements that you already have. The ICO has released a template that just gives us, just where that standard clause is, that shows, okay, we're now third country. Whether it's official now or not, it's still in preparation stage. But you see, those data processes is just that standard clause for now that needs to be changed, and that shows that you're in the third country. This ensures accountability, as a data controller, that you are actually accountable for the data that is being sent out to your processors. Now, this is the one, that's new. Now, as a third country, we have to designate an EU representative. In Article 27, it specifies which non-EU organizations are required to appoint a representative based in one of the EU member states. Basically, what I'm trying to say here is that if your organization does not have a base inside the EEA after the exit date, the EU GDPR requires you to appoint a representative in one of those states. Now, if you're operating in 3, 4, 5 of those EEA states, you now need to choose one of those states and have an EU representative appointed there. How you make that decision of which of the states you're going to appoint it in is up to you. Maybe you're a point where you most have the most clientele or most data is coming out of, or maybe that's where you frequent most. Whatever it is that you use to base your decision, that's fine. But if you're operating in any of these states, you have to choose one place. That is, if you don't have a registered base there, and now appoint an EU representative. This representative will need to be authorized in writing to act on your behalf. And that person or that body is who is going to act on your behalf regarding everything concerning EU GDPR compliance, to deal with the supervisory authorities in place or the data subject in regard to this matter. This representative can either be an individual, it could be an individual or a company or an organization that is already established in the EEA. You could have a law firm per se, a consultancy, or a private company. But in practice, the easiest way to appoint a representative is a simple service contract. But remember, you have to identify this representative in all your privacy notices to your EU data subjects, in your privacy policy that you've got in the office, in your privacy notices that goes out to you on your website, everywhere, because that person must be identifiable, that person must be easy to reach, because anything concerning GDPR compliance, it will not be given to you, but to this representative whom you have authorized in writing for this. These details must be made readily available. Now, you have to establish data breach reporting procedures and verify country by country breach reporting procedures. These procedures have to be put in place because whether through a hack or any other kind of data breach, you have to mitigate your exposure to fines and reduce your notification obligation if there is a data breach. Now, with every data breach process that you have in place, you have to stipulate what is the EU's representatives' roles and responsibilities in the event of this breach. Because now, as a third country, is going across the border, as I would like to say it. And so you have to specify that. And by country to country, what is it that they consider important in their data breach procedures, and now inculcate it into what you have as a practice. Another fun fact, I'm not sure we should have called it fun fact, but it is amazing to realize that an average of 42 breach notifications are reported every day in the United Kingdom. That is amazing. It's amazing. We have one that is has been on the news a bit, of the British Airways, where the ICO has announced its intention to issue an equivalent of 183.39 million pounds fine to the British Airways, which the British Airways is kicking against that, And the incident occurred apparently in September 2018, where the website diverted users' traffic to a hacker website and this affected the personal data of at least 500,000 customers. There's another one, the Cathay Pacific Airway, but this fine was made under the old DPA, and they were fined 500,000 pounds for failing to protect, which is the highest amount that could be fined under the DPA, for failing to protect the security of its customers' personal data. This happened between, I believe it was between October 2014 and May 2018. And that was actually, the blame was put on the company for the computer systems lacked appropriate security measures. So you see why it's really, really important to have our data breach processes, have our processes continually updated and improved. That those are the two cases that came to mind when thinking about the notifications that we do have. If you do have any specific questions regarding the 6 key actions, which you can see here: conducting an audit, informing, and especially when it comes to the EU representative, as I've said, please do put in your questions in the question box, and during the Q&A, we will answer that. We will answer that. Sorry. I hope we all enjoyed that. Now, thank you so much for listening to that, and I'm trying to look through the questions that have come in. I think some of the questions that have come in have actually been answered, but I'll go through that. Yes, got Ronald here, as it says, do you think the UK will automatically be awarded adequacy status? And yes, and that has been answered. It's no. It's not going to be automatic. The EU Commission has made that very clear. And the only update we have on that is that they've started the process of looking at what we've got in place. Yes, the UK GDPR is in place. Now I think they're going to decide, is it adequate enough, Oh, wow, this is an interesting one. It says here, I have a question here from Sylvia that says, sorry, let me make sure I got that right, Sylvia. It says, what data breach cases paved the way for the new legislation? Okay, that's because I did mention that the UK was instrumental in paving the way for this legislation. Off the top of my head, there are quite a number of cases. I think in all there were 8 main cases that actually paved the way for this. And we had the one that was by Wonga Loans. I think that was the first one I can think of, where over 250,000 people bank details were compromised. I don't think they've found, the exact culprit of what happened there, but I do know that that happened, and that was a major case. And we have Morrison's. That was a big one. I think Morrison's customers, Morrison, it affected about 100,000 customers, and we had payroll data, and it was from a disgruntled staff apparently. And I think as of now, he's still serving his prison sentence for that. We have another one, Brighton and Sussex University. The figures there are unclear, but I do remember they were fined about £325,000. And in that particular issue, they had a number of drives that were decommissioned, because in that case there were drives that were stolen. And the bone of contention here was actually because those drives by right should have been destroyed if they had followed their retention properly. What else? What other questions do I have here? Okay, back on that data breach, we still have one it's a major one, and it's from LinkedIn. For us professionals, I think most of us are on LinkedIn, but apparently there was a breach, and where we have 165 million accounts were thrown into the dark web, the reason after the investigation was found really was because of poor security in the sense of password security, putting up our passwords, getting proper passwords to secure and that is one of them. And yes, Krista, I have answered that question about locations. Your question here says, I have locations in the UK, Ireland, and France. Can I appoint my legal staff member in my Ireland office as my EU representative? If it is a registered office, what it is that if you do not have a base in any of this, that is what that is what that is what will make it an absolute necessity for you to have an EU representative. So I'm trying to get the questions out here. Let me see. Oh, hi, David. This is a very specific question you have here. I think maybe it will need more explanation. I believe I will have your email and I can get back to you on that. Your question is about having a data transfer agreement. I'll get back to you on that if we can have that one-on-one so I can really have an understanding of what you're asking here. Here's another question from Laura. We have a question that says, how long do we have before we appoint an EU representative? I think for now, it will be after the transition stage, after this implementation stage. That is when we actually kick into gear of being a third country with all things in place. Right now, everything runs as is for now, but all those things are really up in the air. We're playing it by the ear and listening to what the UKTF, remember the task force I spoke about? That's what we're waiting for, to hear what they've got in place for us. I hope that answers your question, Laura. Okay, I think I've covered all the questions that may be here. Okay. All right. Thank you very much. I hope this was very informative for you. As I said before, we are Risk Crew, and we do and we do ask that you do get in touch with us if you have anything. We offer DPA 2018 and GDPR compliance services. If you'd like to get in touch, those are our details. We are located at 5 Maltings Place near Tower Bridge, London. Our email is information@riskcrew.com. That's our number all there, 02036531234. And do visit the website, www.riskcrew.com. And I hope to see you soon. If you have any more questions, feel free to send an email and I will get in touch, or one of my colleagues will get in touch with you. David, I have not forgotten David Saunders. I will definitely get in touch with you so we can go through what you're asking concerning data transfer agreements. Once again, thank you so much for joining the webinar and have a good afternoon. Thank you.